Okay. So I'm going to welcome everybody today, and it's great that so many people have logged on. And today's topic is around the courtroom experience and how to prepare and what to expect. This is the third webinar in our series with the Legal Aid Board. Our previous recordings are going to be available in the chat. And so far we have covered how to make a legal aid application and the role of the solicitor, and Stephen has really generously brought us through that. The webinars are from a parent's perspective, so questions parents have asked us, and we put them towards Stephen, and he gives us his viewpoint from a solicitor's viewpoint. So for those of you who don't know me, my name is Niamh McCarthy, and I work with the Parental Advocacy Service, which is delivered by Barnardos, and we support all parents going through childcare proceedings, not only in the court, but also with tools and meetings. And I'm going to allow Stephen to introduce himself.
Yeah, thanks very much for that, Niamh. So my name is Stephen Cahill. I'm the managing solicitor here in Chancery Street Law Centre. So that's a dedicated law centre that's specialised in dealing with childcare matters. So our law centre is co-located, so it's in the same physical space as the childcare courts in Chancery Street. And we deal with childcare cases as kind of 99% of our day-to-day work.
Great. Thanks, Stephen, and thanks for giving up your time today. So when we were asking parents for questions and feedback for today's webinar, they kind of asked us a lot of questions about before actually going to court, and then what it's like during it as well. And they have a few questions around after. So if we start with just before. So if I'm a parent and I've done my legal aid application, I have a solicitor, I have received a letter that has said, this is my court date. Is that how I'm notified that I'm expected to come to court, or was there any other follow-up letters?
The short answer is that it depends. Okay. So quite often, the first time the parents will receive formal notice of an upcoming court case is when they're served with those court papers, served with notice of proceedings. And the statute sets out that the minimum notice that a parent is to be given for each type of application. So for an interim care order application, for example, a parent is to be given a minimum of 2 days notice. So you should receive that letter a minimum 2 days in advance of whenever the first return date is for court. Now, there are certain circumstances where you'll get more and circumstances where you may get even, in fact, less notice than that. So, for example, in the case of an emergency care order, or where a member of An Garda Síochána has removed a child from the care of a parent, the application is made in much more urgent, rushed circumstances, and the parent will be given perhaps very little and potentially even no notice of that application. So there is in fact provision for these cases to be heard without a parent being given any notice. Now, the courts would be very, very slow to hear a case where a parent hasn't been notified. But on the flip side of that, a parent may have much greater notice of an intended or upcoming application than simply when they get served with the paperwork.
Yeah.
The Child and Family Agency, for example, will have made that decision to apply for an interim care order, a supervision order, or whatever other relief they may be looking for. That decision might have been made at a child protection case conference, for example, at which a parent was present, and the decision might have been made then to apply in due course for an interim care order. So it very much depends on the circumstances. So ultimately, yes, a parent will be notified, should be notified, and ideally will be given as much notice as possible.
Great. And for some parents, they may have had to leave the family home, or they may not have a family home at this moment in time, given their circumstances, and maybe transient. And in those circumstances, if they are not in any one fixed spot, so they may not receive the letter. How would you advise that parent?
So ultimately, service is a matter for the Child and Family Agency. It's
Okay.
something that they must satisfy the court that they have taken appropriate steps, or that they have served the parents in accordance with the court rules. But you're right, there are certain realities where someone doesn't have a fixed abode or somewhere reliable to which they can receive correspondence. It's much more difficult for the Child and Family Agency to show that they have, served this person at their known address. So it may be that they just formally write to last known address. It may be that if a parent has a phone number, for example, or email, that the Child and Family Agency might apply to court for what's called substituted service. So to allow them to notify a parent by a means other than by letter, so by a text message perhaps, or by an email. So there are other mechanisms around, but ideally, regardless of whether a parent has a fixed accommodation or stable tenancy or not, ideally they would be in contact with the social workers, who should be keeping them updated in person at a minimum.
Okay, thanks for that, Stephen. And now, if you are my solicitor and we're going to court, will I get to meet you before court?
Yeah, absolutely. So a person can apply for legal advice without there being a court case actually in being, or a court date having been set. So we've always said, the sooner you apply for legal aid or advice, the sooner you can meet with your solicitor, the sooner you can start receiving appropriate advices. But if the first you hear about a court case is, you receive a letter notifying you're in court, you should then immediately apply to your nearest law centre. Your application will be treated as a matter of urgency, and you'll be assigned the first available solicitor. So your solicitor then will try and contact you directly to arrange the earliest possible meeting to start preparing. So it may just be a phone call in the first instance, and then with the view to arranging in-person consultations, perhaps once the solicitor has a bit more of the background information and backing reports and so on.
Yeah. And in order for you to help me prepare, what do I need to do to prepare?
There's no definitive steps that I would say a parent should be taking. It would just be more helpful, I suppose, if you could be available to perhaps assist your solicitor. So bear in mind, part of the role of the solicitor is to assist the preparation of your defence of whatever application it is you as a parent are facing. So it may be that the solicitor might ask you to make yourself available to sign perhaps consent forms for your solicitor to write to professionals with whom you might have been involved, who could give you a helpful or favourable report for the purposes of court. Or it may be more expedient and easier for the parents themselves to go directly to this person to get a report. So if it's your GP, for example, or a key worker, something like that, your solicitor may ask you to try and speak directly to that person to see, can you obtain a report? Then kind of aside from that, if there's any kind of background information that you think would be relevant or of assistance to your solicitor, it'd be helpful if you could make that available as soon as possible to your solicitor. So if there were previous court proceedings, previous court orders, if you could get copies of those and give them to your solicitor, that would always be very, very helpful. But really, that's just about it. It's about just making yourself available to meet with your solicitor. One thing I've seen many parents do, and they find quite helpful to do, and indeed as the solicitor I find it quite helpful when a parent does this, is the papers that you're served with would include what's called a grounding affidavit, which kind of sets out in a nutshell what the Child and Family Agency's case is, in a nutshell what are their concerns. And I've seen quite often parents might prepare just kind of little written statements or rebuttals to each of those CFA concerns. And that's very helpful. So your solicitor knows right from the beginning what your view is of the CFA concerns, or if you feel they're inaccurate and so on.
Okay, so that's really important to bring with us the notification we receive, because that's basically telling us what or the Child and Family Agency's concerns are, and what our viewpoint then is around that as well as parents. One of the other things when parents are going to court that they worry about as well is, like, do they need to be dressed very formally, or do they have to wear a certain type of clothes, particularly for parents who are struggling with money or the cost of living crisis? This is very daunting for them.
Yeah, no, I totally understand that concern, but thankfully that's something that a parent doesn't need to be concerned with at all. So the family law courts, and in particular the childcare courts, are designed and are supposed to be as informal as possible. And you'll even see that with how the lawyers are dressed, for example. So the barristers wouldn't wear their wigs and gowns in a childcare court that they might wear in criminal courts, for example. So the courts are absolutely designed to be informal, and I hope that that's not something that would be a source of stress or anxiety for a parent. Yeah. It's not something that will factor into any consideration.
Yeah, no, because people feel sometimes they may be judged by how they look arriving. The other thing is, for parents as well, when they receive their hearing is scheduled for 10 a.m., but as we know, there may be a long list scheduled for 10 a.m. So what time should parents ideally arrive at?
Yes, so the notice of application sent to you will say what court you're in and at what time. So in Chancery Street, matters are made returnable. So the list starts at 10:30, at least in theory, in Chancery Street. But that doesn't mean, you're right, that your case will actually go ahead at that time. Ideally, you would have had ongoing contact with your solicitor in advance of the hearing date, and your solicitor would hopefully arrange directly with you a time that's appropriate. So that might be 10 o'clock, so 30 minutes advance would ordinarily be plenty of time. It depends on the nature of the application. If it's an initial interim care order application or a very contested matter, then yeah, the solicitor might ask to meet with you even earlier if possible. But you're right, it's an unfortunate potential outcome that you may be left sitting around for a number of hours, even if you're asked to turn up early. But there's nothing we can do about that, unfortunately.
Yeah. And just there, Stephen, when you said it might be a very contested matter, what would that mean, or what does that look like?
So as a respondent to an application in the childcare courts, the parents have a number of different options to them. So they can, firstly, what's called consent. So a parent might agree to an order being made, and they might give that consent for any number of reasons. So if matters are proceeding on consent or by agreement, they're less contentious, there's less at issue between the parties, so it's not going to take as long in court. Whereas if a matter is completely contested and is entirely opposed, then the matter is much more contentious, and you really need to go through every report line by line by line with the parents to take the detailed instruction on it.
Okay. And is there something that happens in all the courts? Is it called a call over in the morning, or what does that involve?
So COVID kind of mixed things up a little bit, and each court operates slightly differently to every other court around the country. So even in Chancery Street, the process is somewhat changing and changeable. The present way it works is that on a Monday, all of the cases for the list are dealt with in what's called just a remote call over. So it's not done in person, just the lawyers remotely. And the court is given just a very brief indication as to what type of case it is. Are the Child and Family Agency looking to proceed, to confirm maybe that the parents are represented, or to flag to the courts that the parents aren't yet represented? But the court will be given a general idea as to maybe will the matter be proceeding, will it be contested, or might there be an adjournment application? So the court will have a vague indication as to what's going to happen with the case on the Monday. There's no daily call over of the list thereafter. That weekly call over on a Monday kind of dictates how the cases are divided up between the 3 sitting courts here in Chancery Street for the week. And then that court list issues the evening before. So the solicitor won't know until about 4 o'clock the evening before what court you're listed in, what judges are sitting, and where you are on the list, whether you're likely to be heard first, second, or 22nd.
Yeah. And I think we've talked about this before, but all courts are in private and they're governed by the in-camera rule. Um, this when I'm talking to parents find that very difficult sometimes to understand. Would you be able to explain it to us?
Sure. So the in-camera rule is it's a rule of court that effectively it's designed to protect the privacy of all of the parties involved in a childcare case, but most importantly designed to protect the privacy of the subject child. What it means is that the court cases must be heard otherwise than in public. So the court cases themselves are heard in private. So the only people who be present in court are those who are a party to the proceedings, their lawyers, the judge, and the registrar. But then it extends beyond the courtroom then as well, this in-camera rule. So any documents prepared or reports prepared for the purposes of court are also caught by this rule, which means that those reports are private and confidential and can't be disclosed to any third parties. And to do so could potentially be a contempt of court, or it could potentially attract criminal sanctions such as a fine or imprisonment. And the in-camera rule, it would also then extend to any social media post, for example, that might identify a child in care or a child subject of care proceedings. So it is very wide-ranging rule that all parents, I suppose, need to be advised on it, and just to be careful about it, because you're right, it is a complex matter, and it's not something that your average parent would know anything about unless and until they meet their childcare solicitor.
Yeah, because as advocates, we will make an application to have the in-camera rule lifted for us to attend and support the parent in court. However, in some instances where there is not an advocate working with the parent, or there isn't one available in their area, parents often ask if their partner, who may not be the child's father or child's mother, can attend with them, or a sister or their own mother. And often this is not allowed under the in-camera rule. Am I correct in that?
Yeah, and I think that's reflective of just how seriously the court kind of treats the in-camera rule and the real importance of the privacy. So even when a parent attends at our offices with a support person, maybe a family member or partner, we'll always say to them, it's great that you have someone who can come here as a support for you, but you wouldn't be, in usual course, be permitted to attend in the actual courtroom. And there's very good reasons for that. So you're right. So that's why the court really wants the professional advocate who has that high level of training and full understanding of the in-camera rule and so on. Yeah.
Thanks, Stephen. When we were talking there, you mentioned, judges and court register, and obviously there'll be other professionals there, such as guardian ad litem and the social worker and possibly the social work team leader, and then solicitors representing the CFA, representing the GAL, and then obviously the parent is there represented as well. What are the roles of, say, the register, for example, and other court professionals?
Sure. So the only other court professionals that will be present during a hearing will be the judge themselves, who are obviously hearing the case and ultimately going to be making the decisions. But then sitting in front of the judge is their registrar. And the registrar is a court administrator, I suppose, that they're there to ensure that the correct file is in front of the judge. They're the ones who'll draft up any orders if they're made, and so on. But the registrar won't be participating in your proceeding, won't be talking to you or making any submissions or anything. The registrar is really, it's an administrative role to assist the judge.
Okay. And if English isn't my first language, or if I have some difficulty with my sight or hearing, or, I need assistance in any other way, would the courts provide that assistance?
Yeah, absolutely. So certainly if the legal aid board become aware that reasonable accommodations need to be made, or an interpreter, for example, needs to be sourced, the legal aid board will book their own interpreter then for the purposes of consultations and so on. But the court services will also book their own interpreter for the actual period of time which you're in court. So quite often you can end up with two interpreters for the same day. But it's just to preserve, I suppose, the independence that sometimes happens. But yes, obviously, if you are going to require an interpreter, arrangements will be made. It's the most fundamental aspect of participation, is that you fully understand the proceedings in order to participate and to instruct your lawyers.
Yeah. And it's such a daunting process as well for parents going into court, and it can be very dysregulating as well. And one of the constant questions we get is, who's going to give evidence and what does that involve? And will I, as the parent, have to give evidence as well?
Sure. So the Child and Family Agency are usually the applicant in these cases. So they're the ones who've brought the case to the court, and they're the ones seeking for the court to make an order. The court can only make an order if it's satisfied that the grounds for that are met. And the court can only reach that conclusion, or otherwise, having heard evidence. And evidence is brought through witnesses, so that the competent witness must attend in person, unless there's other applications being made. But generally, a witness must come to court themselves and must give their evidence directly. So usually the main deponent or witness will be the social worker. They're the moving party. They're the one asking the court to make an order. So they then are there to give their direct evidence first. And then they're cross-examined by the lawyers for the parents, or potentially for the guardian ad litem then as well. So if the Child and Family Agency have other concerns, they might call who they believe is the appropriate witness to evidence that. So it may be that they call a GP, school teachers, or other professionals who've worked with the family. So in advance of any professional like that giving evidence, they will have prepared a report setting out briefly the evidence that they're likely to adduce. So there's no ambush. A parent and their lawyers will know what the evidence is likely to be.
Okay.
And therefore the parent can prepare for it and can instruct their lawyers. But then as to whether or not a parent wishes to give evidence, that's entirely up to them. So once the Child and Family Agency case concludes, it's then up to the parents and their lawyers to decide if they're going to give evidence or not. And there's no obligation to give evidence. And it depends from case to case as to whether or not we think it might be advisable or not to do so.
And those reports that are prepared in advance, Stephen, do they go directly to the parent, or do they go through the parent solicitor and the parent solicitor holds them?
Yeah, so they'll be sent into the court office, so to be put onto the court file and then circulated to the parents' lawyers. So again, those would be reports covered by this in-camera rule, so they're prepared for the purposes of court. So technically they're the property of the court in any event. So a parent is entitled to go through them, of course, and would have to go through them with their client. And you'd be entitled to come in and view any reports at any stage in your solicitor's office, but they just couldn't give you copies of those reports.
Yeah, because often parents ask, can I get a copy of that, or
Mm.
where is that outlined? And I think you've already touched on that, given the nature of what the court is hearing on that day and the nature of the order, it may be a short hearing or a long hearing, so it's very individualized, I imagine.
Yeah, absolutely. So an application could be very, very brief, so literally talking about a matter of minutes, or a hearing could extend up to for a number of days or indeed weeks at a time if they're particularly contentious.
And if I'm a parent whose children are subject to an interim care order, and we've had a number of 28-day orders issued, how long can that go on for in the courts before either we look at reunification as a possibility and the children returning home, or that the CFA may take the decision to look for a full care order?
Yeah, so there's no hard and fast rules. In the Dublin courts, there's in place what's called a practice direction. So that's a direction it was designed by the judges to set out overarching aims and ambitions for how childcare cases should be managed. And in that practice direction, the hope or the aspirational aim is that childcare proceedings would be concluded in or around 12 months of them commencing. Um, Again, different districts around the country manage childcare differently. Some are more likely to set a date for a care order much quicker than others. And that's again for a whole host of reasons. It may just be logistical reasons, or it may just be how childcare is managed, that some courts only look for short periods of interim care before care orders should be sought, or and then granted or refused, perhaps looking for kind of short care orders from, in the beginning. So there's no definitive answer, but by and large, after about kind of 5-6 months, that would tend to be when the Child and Family Agency would seek hearing dates to be listed for a care order, and that's always presented to the court as being by way of a parallel plan, that just by fixing hearing dates, that doesn't rule out reunification,
Okay.
the interim.
Yeah, because parents get very worried when they
Mm-hmm.
hear dates being set for full care order hearings. We've only a few minutes left, Stephen, and I still have loads of questions from parents. But one of the things that we're often asked about is, and I think you've already spoken to, the judge is the person who makes the decision and the judgment in court. But if I'm a parent, do I get a copy of that judgment? Am I allowed, do I get a copy of the record or the transcript from courts, or how does that work?
So technically, any parent can apply for a transcript of what's called the DAR, the digital audio recording of the proceedings. The reality, however, is that's very expensive, so that isn't something
Okay.
that's actually done. I think usually the way it would happen is that your solicitor after court would write to you, would set out, what occurred in court, what evidence was adduced, and then a note of any judgment or decision given by the court. And then you would also be given a copy of any orders that might have been made. So I think that's generally how you'd be treated after the court in terms of your entitlement to look back on what occurred.
Okay. This is my final question because we're about to run out of time. But obviously, we've been through court and we've got an order, and we're just wondering, can that be appealed then? What's the next step for parents?
Yeah. So any decision of the district court can be appealed to the circuit court. Ordinarily, that would need to be done within 14 days of the making of an order or the refusal of an order. To do that, you need to file your notice of intention to appeal in the court office within the 14 days, and that's something your solicitor can assist you with. So you can file that notice and then serve it on the other parties as well.
Okay. And if I'm making an appeal, do I have to have a good case to make this appeal?
So a person can apply to appeal any matter. That's your entitlement. But as to whether or not he'd be given legal aid for an appeal that doesn't have good grounds is a different matter. So legal aid isn't automatic for an appeal, that the legal aid board would need to look at some of the grounds for the appeal. There's not a strict merits test if it's to do with the welfare of a child, for example. So the legal aid board are more likely to grant legal aid, even if they don't think it's necessarily likely to succeed, but there may be other reasons or grounds to appeal it. Yeah.
Okay. Thanks so much, Stephen. That was very quick half hour and a whistle stop tour of the courtroom. Um, I would just like to remind people, please feel free to give us any feedback or any further questions for our upcoming webinars. Daisy has put it all in the chat, and I'm going to just share our QR codes as well for further information as well. And our next upcoming webinar, as I said earlier, if my screen would move on, is on Tuesday, the 12th of November. And some frequently asked questions to ask during childcare proceedings, which hopefully we'll get to more of the questions from today. And our last webinar in this series is what is a non-relative kingship care and family mediation. So you can scan here for the feedback form, and I'll leave that up for a minute. And then if you would like some additional information on all previous recordings are on either of our sites here as well. And I just want to thank everybody for coming and a massive thank you to Stephen as well for participating. Thank you
Yeah.
so much.
Thanks very much, Niamh.